Hi, my name's Andrew Charlesworth, and I'm a Reader in Information Technology Law at the University of Bristol. University of Bristol is one of the partners in the project Privacy Flag. One of the things that I've been looking at in the project is the different approaches that countries take to data protection law and privacy. And one of the big divides in the world today is the difference between the European Union and the United States. The European Union has a very complete data protection regime. There are very clear rights and obligations. There is overarching national legislation providing for those rights and obligations. The US, by contrast, doesn't have an overarching set of data protection rules. It has a whole range of rules that apply to different sectors of the economy. So, for instance, you will find data protection laws for finance, you'll find data protection laws for school, you'll find data protection laws for electronic commerce. One of the problems with this is that this means that EU and US law are not entirely compatible. The EU, when it deals with other countries, and when companies in the EU are wanting to transfer data outside the European Union, wants to ensure that its citizens' data is effectively protected. One of the ways it does this is through something called an adequacy ruling, where the European Commission looks at the laws of other countries and decides whether or not they provide proper protection to personal data. And if they don't provide proper protection, the country is deemed not to be adequate, and then all dealings between companies in the EU and companies in that country have to be dealt with by contract. This is not a particularly efficient way of doing things. It's much better if a country can be shown to have adequate data protection laws. Unfortunately, as we've seen, the US law doesn't have adequate data protection laws in the EU sense. So over the years, the European Union and the United States have tried several times to come up with an agreement that allows for the transfer of European Union citizens' data to the United States, usually for commercial purposes. The most recent attempt at this is the EU and US Privacy Shield, an agreement between the EU and the US that addresses how organizations in the US accepting personal data from the EU should handle it. Unfortunately, the Privacy Shield agreement is controversial. This means that there's uncertainty when businesses deal with the United States. It means there's uncertainty when EU citizens are sending their data or allowing their data to be used by US companies. Privacy Flag provides a way of permitting individuals and indeed permitting companies to assess whether or not their practices are broadly in line with, in conformity with, EU law. By providing a simple interface, by providing simple questions, you can get some idea of whether your data is going to be used appropriately, or as a company, whether your approach to personal data is potentially in conformity with EU law.